Good afternoon, everyone. Thank you all for registering and thank you all for your time today. I could not be happier with the lineup of panelists and with their engagement to discuss, to share the knowledge and experience in several key topics of bankruptcy with us. Insolvency law is an area that was already under the spotlight before the crisis triggered by the COVID pandemic, and that we expect only will be more strategic in order to allow the companies and businesses in general to recover from the current economic scenario. Today's panelists are all well known, so this introduction will be brief, then we can move on quickly to learning from them. First I'd like to introduce you to Professor Sheila Nader-Cerezetti. She got her PhD in law from Universidade de São Paulo, where she's been teaching business law, including bankruptcy, since 2013. She's also the managing partner of Nader-Cerezetti Advogados. Professor George Triantis began his career in Canada, where he received a JD from the University of Toronto. He then earned an LLM in Virginia and a JSD from Stanford, and before returning to Stanford, where he teaches bankruptcy, contracts, and transactions, Professor Triantis was a professor at Harvard Law School. Professor Marcelo Sacramone teaches business law at the Catholic University in São Paulo, and before that he earned a master and a PhD in law from Universidade de São Paulo. In addition to that, he is the judge in charge of the second bankruptcy court in São Paulo. Professor Satiri teaches commercial law at the Universidade de São Paulo since 2003, 1 year after earning his PhD at the same school. In addition to the academic work, Professor Satiri practices bankruptcy and corporate law. And Fabio Weinberg Crocco is an associate at Sullivan & Cromwell, where he practices bankruptcy and restructuring. For instance, he is currently advising Alitalia in connection with its Chapter 15 case and Venezuela's interim government with restructuring of its sovereign debt. His legal education started in FGV in São Paulo, continued with a master in Oxford and 2 more in Stanford. So this webinar will be divided into 3 parts. The first one, probably shorter, aims to discuss the effects of the pandemic in bankruptcy proceedings. It's then followed by discussion of what we call non-pandemic related issues, somehow more structural, and what we can do to improve how it's done in Brazil and in the US. The last part will discuss cross-border reorganizations under an American perspective and the implications for foreign, including Brazilian companies. We invite you all to submit questions and the panelists will be happy to address them all. So we'll start with Professor Triantis. He will give us a glimpse in the difference between the crisis, the business model crisis, economic crisis, and the financial liquidity crisis, this triggered by the pandemic. So Professor Triantis, thank you for having you. I believe it's you on mute, yeah.
The mic is off. You're mute. Don't worry, Jeff Bezos was mute yesterday.
Okay, sorry. Thank you, Vinicius, and thank you for the opportunity to participate in this panel. We've already had the opportunity to chat as a panel before, and I've learned a lot from our conversations, and I look forward to the discussion today. I thought I would say something about some of the general principles that undergird the U.S. Bankruptcy Code and that have at least since the 1978 code was passed. The courts and the code and the scholars are all very conscious of a fundamental distinction between, as you mentioned, Vinicius, what's called financial distress and what is called economic distress. Financial distress really has to do with the financial statements of a corporate debtor. A company is in financial distress if it is insolvent, if it owes more than the value of its assets. Much more importantly, and especially in current conditions, a company can be in financial distress because of illiquidity, because even if it's solvent in a balance sheet sense, it cannot meet its obligations as it comes due. It just doesn't have the cash flow to meet its interest payments, its rents, its wages obligations, and so on. And that's financial distress. Economic distress doesn't look at the financial statements of the company, but rather looks at the efficiency of the business plan, of the business model. Is the company making things that nobody wants to buy? Is it selling them in ways that don't make any sense anymore? Does it need to be restructured, but restructured in its operations in addition to or separately from restructuring on its balance sheet? And the reason that those two concepts are important to keep separate is because there are the debtors that go into bankruptcy that have one and not the other. And notably, they are debtors that almost all debtors that go into bankruptcy are financially distressed. And the big question for the bankruptcy process is whether they are also economically distressed. I like to use the metaphor of a fire alarm, that financial distress is like a fire alarm ringing in a building. Something has triggered it. Something has triggered the illiquidity, the cash flow problem, the insolvency. And then the question is, what triggered it? Is it a false alarm? Is it something exogenous? Or is there actually a fire going on in the building? And the metaphor of the fire is that this company's business plan needs to be overhauled in addition to its financial structure. And that may or may not be the case. And we'll talk about this in the context of the pandemic, no doubt. But there is no point turning off the fire alarm until you first checked whether there's a fire and you put out the fire. And similarly, when a company goes into bankruptcy, there's no point restoring solvency and restructuring the company unless the process also investigates whether the business needs to be restructured economically. This means, do divisions need to be shut down? Do employees need to be laid off? Do managers need to be replaced? Does the marketing strategy need to be changed? Should the company merge with another company? These are all things that have to be considered. So in the pandemic, and we can speak to this, I think there's a blend. I think there are some companies in the United States that are filing for bankruptcy that are in financial distress but don't need significant economic restructuring. And there are some who have needed economic restructuring for a long time and now are going into bankruptcy. And those changes finally need to be made and are accelerated. And then my third category are ones where the pandemic has fundamentally changed markets, and so that there needs to be economic restructuring as a result of the pandemic. Just an example, then I'll stop. One industry that is experiencing a lot of bankruptcies in the United States are retailers, especially bricks and mortar, not internet retailers, not Amazon by any means, but bricks and mortar retailers, and the chains are going into bankruptcy because they were shut down for a while. The demand is much lower. The cash flow has decreased, and yet they continue to have obligations to pay rent and interest and wages and so on. And when they go into bankruptcy, they have to think, well, how many stores should we retain? How many should be shut? How many don't make any more sense in the new world? Well, this has been creeping up on them for a while. I mean, the dominance of internet retailing is not new to the pandemic. And these changes were due. They've just been accelerated by the pandemic. And if you will, that can be interpreted as a positive, a silver lining in the pandemic. So Vinicius, I'll just stop there, but that's a quick introduction.
Thank you a lot, Professor Triantis. It was super clear and important to level the playing field here. And now I would ask Professor Cerezetti. So in view of this scenario and this new scenario accelerated or created by the pandemic, then should the statutes be amended to address these particular issues arising from it, and which rules, and if we are seeing a movement towards these changes in Brazil, is this being pursued effectively? Are we on the right way?
So good afternoon. First of all, thank you, Vinny, for having me here, and thank you all for being also here with us. I can only speak about the Brazilian reality, of course, and I will restrict my comments to that. And what I can say is that long before the pandemic, the Brazilian economy was already very fragile. The pandemic certainly aggravated it, and it demanded urgent reactions that unfortunately have not yet been presented, neither by the government nor by our Congress. And this means that we are now 4 months into a global pandemic, and we are still waiting to see rules that are capable of helping business face this massive crisis. At the moment, social distancing is already being reverted, as we know, but the economy has not yet given signs of recovery, and we are still waiting for measures that are able to tackle the main economic problems caused by lockdown, and also those that were caused by the economic crisis itself. So amending some statutes would certainly bring some relief to the economic agents. But this is not only the case with insolvency law, but with other statutes related to the economic life as a whole, and also with social matters. So, but if we think specifically about our bankruptcy system, there are certainly a few rules which even before needed to be modified, and now such need, at least for me, it seems that it's much more evident and demands an urgent response. And if I were to think about which would be those main rules that I think we should be focusing on, I would say, first of all, reorganization of small and medium-sized companies and enterprises. And I know Marcelo Sacramoni will speak about this soon. Those enterprises have been extremely affected by the pandemic and by the lack of a reasonable procedure for rescue, as well as for a fast liquidation. We have a problem both in reorganization procedures and also in the liquidation procedures in bankruptcy. We also need rules on deep financing, and we'll talk about this as well, so I won't say much. We all know that new money is key to a successful reorganization, but it's not something we see in our reorganization cases here in Brazil, since there is no certainty at all on how the loan will be treated and how it will be paid in the future. And I think we should be talking not only about DIP given by private agents, but also we should be talking about public financing, something that we are not talking about here in Brazil, at least so far. And then, of course, rules on cross-border insolvency. It's funny that our companies and creditors of Brazilian companies have been filing Chapter 15 cases for a while now, and Fabio can talk about this with all his experiences. And Brazilian judges have been dealing with this on a case-by-case approach. And as a jurisdiction, we ask others to cooperate with us, but we have no rules in place to also be cooperative. And as a consequence, I think there is a lot of uncertainty on how rights of creditors are to be dealt with in cross-border cases. And certainly this uncertainty endanger the interest of lenders and other possible creditors to deal with Brazilian companies. So I think we have this bunch, this whole group of rules that need to be changed, amended, and the pandemic will only make it more evident that we should pay attention to this. But instead, I think what we have now, what we see in Congress right now is a bill, number 1397, aiming at setting forth a moratorium as well as a so-called preventive system, which would bring a standstill, I mean a non-bankruptcy stay. So instead of looking at all those rules, what we have now is this bill, this proposal of giving moratorium and giving this standstill. And this standstill depends on the previous filing of a specific lawsuit. So my perspective on this is that this would only cause the congestions of our courts in the moment where the capacity of these courts is already pretty much fragile due to the increase of workload that is naturally happening and deriving from this huge economic crisis. So just to sum up, right now, the Brazilian sector, from my point of view, is simply at the mercy of the crisis and still awaits for some sort of aid. And I hope this will come anytime soon, if maybe by changing the whole law, something that we can talk about later as well.
Thank you, Professor Cerezetti. I'll handle it to Professor Triantis. I think he shares some of your concerns, and probably the last one on the congestion and capacity of the courts for the next quarters and years to come. So, Professor Triantis.
Yeah, so I think in April or May, I was quite concerned about congestion in the courts, because the notion that there would be a surge in the courts of bankruptcy filings was quite obvious at that point. When it was going to happen or what the curve was going to look like was a little bit unclear, but that there would be a surge, at least the way it was in the financial crisis, was fairly clear. You know, I'd be interested in Fabio's experience and also in the experience of his bankruptcy partners. My sense is that it hasn't been yet quite as bad as people might have expected. And there was a group of there's a group of bankruptcy scholars, academics, who wrote a letter to congressional staffers suggesting that steps be taken in order to address the congestion. I'm not sure what has been done there, but the things that I've heard from bankruptcy practitioners is that the congestion hasn't been that bad, and that Zoom has actually worked pretty well. Sort of remote hearings, whether it's by Microsoft Teams or Zoom, has worked quite well. So if that's the case, and that's my casual empirical observation, why has it not been a problem yet? Well, I'm going to be a little bit of an advocate for the U.S. bankruptcy system, but it is it's a very sophisticated system for many, many reasons. First of all, the 1978 code was a very well drafted code. Second, it allowed the flexibility for judges to work within the framework of rules under the code, and that specifically in certain districts, the judges have reached a high level of sophistication, and that the practitioners, the lawyers, are very sophisticated. And therefore, there are some standard patterns, there are some standard routes, avenues that were established that actually don't require a lot of time in the courts in order to be able to pursue. So if you will, it's, you know, it's like if you take the analogy to a hospital, there's certain protocols, some standard protocols that actually don't require that much judicial time, don't require that much of a high touch type of an atmosphere. I think the third thing is that, again, because of the sophistication of practitioners, well, bankruptcy works best when restructurings and arrangements work in the shadow of bankruptcy without actually filing bankruptcy. In other words, when people negotiate outcomes that reflect what would have happened in bankruptcy without having to actually do a bankruptcy filing. So we do know that a lot of attempts are made by the creditors and by the debtor to resolve the financial distress even before filing for bankruptcy. And that in many cases now, by the time they file for bankruptcy, there's already a framework for a plan. There's already a strategy that has sort of been proposed, discussed, and even agreed to by some of the major creditors. So we'll talk about debtor in possession financing, but in many cases that's been lined up before the bankruptcy. If the company is going to be sold or the assets are going to be sold, in many cases that's been sort of more or less settled, or at least the first steps have been made towards a sale before the filing of the bankruptcy. And so because I think more has been done before bankruptcy, because some of the patterns or the protocols for dealing with bankruptcies have now become standardized because of the extensive experience under the code, and because it's easier once things have been standardized, it's easier to do things remotely rather than through in-person hearings. My guess is that's why we haven't had the sort of crisis that we were expecting in congestion, at least up to now. Who knows what's going to happen in the future, but at least up to now, my understanding is that it hasn't been as big of a problem. There were suggestions perhaps of moving some judges from less busy jurisdictions to more busy jurisdictions, of bringing back retired judges, of using more, not judges, but masters or secondary officers and trustees, moving some functions onto them. I don't know how much of that has been done, and my guess is because the problem hasn't been as severe as what we expected. I don't know if, at least in the U.S., I'd be curious what's happening in Brazil, but at least in the U.S., Fabio, do you have a different impression?
No, and first of all, thank you very much for the invitation. It's a pleasure to be here. But I agree with you, George. I share the same impression in the U.S. I would just add that some venues are busier than others. So you have, for example, the Southern District of Texas, which is one that has been busier, especially in connection with oil-related bankruptcies. So with a crisis in the oil prices, you had several filings there, and that's a jurisdiction. Just to give the context to the audience, in the U.S., unlike in Brazil, you have significant flexibility to choose the venue where you're going to file, and some venues tend to offer some advantages, and one of the advantages is expertise. So the courts of the Southern District of Texas are very familiar with oil cases, and as my perception is that because of that, they have been busier. I would also add that technology has been helping a lot. Several hearings using Zoom or other technologies have worked relatively well, sometimes with a few interruptions and ordinary problems, but that has been very helpful. And another thing that I would add, having practiced in Brazil and the US, I think the role of how the system works here is very different in terms of process as well. So US bankruptcy judges have a lot of support from practitioners as well. Something that's surprising to Brazilian practitioners, the fact that lawyers here submit draft orders to judges. And that's very helpful in the US context, because you know more or less what you're getting, and oftentimes these orders are heavily negotiated, very technical, and the debtor and the creditors also can get specifically what they want, and they free up a lot of time of the judge. So this tends to be also very helpful, and so the process, from my perspective, has been working pretty well so far, and less congestion than we expected back in March when the markets were melting.
Great. Thank you, Professor Traentis. Thank you, Fabio. Thank you for your contribution. I think we'll get to debtor in possession financing in a second. I know it's a core discussion here, but I'd like to, before that, ask Professor Sacramone a broader question. Well, he's been for a while.
May I just comment one point related to that one?
Of course, Professor Sachiro, please jump in. Yeah, anyone can jump in at any time, please.
Because we had a similar issue here. We have a similar worry here about congestion, of course. And so we had this work in order to flatten the curve of judicial lawsuits, and that was important for some time ago. And we have not seen that increase in the number of procedures here so far. We don't know because we are a little bit late comparing to United States and especially comparing to Europe. But well, we have an increase in the number of involuntary liquidations and some liquidations, but not really reorganizations. Reorganizations, we are keeping a quite fair number. But the judiciary is trying to find alternatives in order to avoid any kind of congestion. And the main option of the judiciary here, and that's the point I'd like to add, is, well, judiciary is as in Brazil, and Fabio mentioned it, judges are very important in the procedures. They are part of the procedures, and almost everything depends on a decision of every judge. And attorneys, well, they do their job, but actually they depend on what the judge will finally decide. So judges have a lot of work to do. And one of the points that have been stimulated here in Brazil, and this is the strategy of the judiciary, is to stimulate mediation. And in some cases, what is being called mandatory mediation. We've been considering to impose any kind of mandatory or discussion or bargaining between parties as a requirement to file bankruptcy, for example. And in these cases, the negotiator should be someone officially appointed by the court. And well, for contracts, litigation, for example, that involve two parties, it seems quite normal. But for collective actions like insolvency ones, I'm not so, well, I'm a little bit skeptical about mediation in this issue, because parties will certainly try to find a solution before filing for bankruptcy, of course. So just to let it mentioned here, we had a quite different strategy from our legislator based on our experience, and it's quite new for us, mediation as well.
That's great, Professor Sachiro, and everyone else, please just jump in at any point. We are here to learn from you. I would like to move on to Professor Sacramone on this exact point that Professor Sachiro just commented on, not only on the congestion of courts, but a broader question on what changes in this process could be performed in order to have a more efficient rhythm and a more efficient bankruptcy proceeding in Brazil, considering your experience and what you've been seeing in the bankruptcy court in São Paulo, Professor Sacramone. Thank you again for joining us this afternoon.
Hello, everyone. Thank you, Vini, for having me. I think I have the same impression as Professor Sachiro and actually Professor Triantes as well. We were hoping that we have really a congestion in the court, but it's not quite bad as we expect, at least until now. And I think the most reason of that is that the organization in Brazil have destroyed the image of the company organization in the market. And if I can show some data about it, I can show you that we have, I think, the not proper incentive or in the organization process. So if we can see, and I think I can show you that. Just a minute, yeah. Can you see? Oh, now, yeah, now I think you can see better, huh? Yeah,
It's on, Professor Sacramone. Thank you.
It's on? Yeah. Based on the collected data, a high number of the judicial restructuring plan are approved. In our case, in our judicial restructuring analysis, only 60.1% resulted in bankruptcy before the first general meeting of creditors. And of all the cases that were submitted to this general meeting of creditors, we have 8% of the plans just approved, and just 20.8% of the plans were rejected by general meeting. The small percentage of rejection may indicate two things for us. First, the plan is really good, but when we see the plan, and actually this is the main features of the plans in relation to unsecured creditors, we have a plan that the majority of the obligation, the maturity of the obligation is 10 years with a discount of 35% and interest of 3% per year. This is related to unsecured creditors. If we analyze the secured creditors, we don't have any kind of difference between them. We have the maturity of this obligation in 10 years as well, and actually a discount of 37% in the original obligation. This can reveal at least, I think, two things. First of all, despite the company no longer being economically viable, the lack of assets would result in a liquidation even more harmful and long to creditors, which suggests a lack of control, at least in the Brazilian organization system, of the business activity by all economic agents, something that Sheila has just pointed out. And I think the second conclusion that can result from the data is that as not all creditors are subjected to judicial organization in Brazil, there is no absolute priority rule, there is no best interest test as we have in the US system. The submitted creditors may be approving plans just to harm non-subjected or more privileged creditors. They asked for, or they approved some plans that they know that will harm some of the creditors, but not them. I think this is the main reason why we have so high rates for approval, but really, really small one for rejecting the plans. Maybe really with this really bad plan that we are approved, this image from the companies are just destroyed, and so that's why our expectation that we would have really a congestion of organization in the court are not, at least until now, as quite as we expected. Quite bad as we expected.
Great, thank you, Professor Sacramone. I think we could go back to Professor Triantis, and then he will be able to share with us Professor Sheila Cerezetti already highlighted how post-petition funding is important and determines the success or not of any restructuring. And Professor Triantis has a great experience on how the post-petition and exit financing evolved in the US and Canada in the past years, and how it became so important and key. And I believe we have a lot to learn from it. So please, Professor Triantis, thank you again.
My pleasure. Yeah, I can give a bit of an introduction, and then presume that we can talk more about it as we compare the regime in Brazil. So one of the few advantages of being older is that I remember the time that DIP financing and debtor possession financing was not a big deal in either the United States or in Canada. It was in the code in 1978, but I would say that from 1978 certainly to the time when I started teaching law, which I practiced a little bit, which was the late 1980s, it wasn't a big part of the bankruptcy process. I would say probably a quarter maybe of the companies or less of the companies that were going into bankruptcy actually got debtor in possession financing. And it's also not surprising that the level of leverage of companies going in bankruptcy and therefore their interest obligations were much lower back then than they are now. So the amount of leverage is much higher and the fixed obligations of companies is much higher now than it was back then. So it wasn't a very big deal then, but one thing that happened shortly after I started teaching, so in the early 1990s, is that there were a couple of banks who said, this is an interesting business opportunity for us, that we will provide debtor in possession financing to companies that are in bankruptcy, and we will make a lot of money doing that. And that was a very, very surprising thing back then, because even the few companies that did get DIP financing, it was their existing lender that would provide them with a little bit more money. But again, very rare, or very not very frequent. And so this notion that you'd get a new lender coming in to bid for the opportunity to provide DIP financing was new in the, as I said, in the late 80s and early 1990s. It was very profitable because debtor in possession financing enjoys very high priority. Sometimes it can even enjoy the highest priority over even secured creditors of the debtor before bankruptcy. And also, if a reorganization plan is going to be confirmed by the court, one of the requirements is that all debtor in possession financing has to be repaid in full. And so it was very low risk back then. I think it almost never was there any default on debtor in possession financing, whether there was a reorganization or whether there was traditional bankruptcy or liquidation. So it was very low risk. The interest rates were healthy. The fees were very healthy. So it was very attractive as a profitable opportunity. What happened, and at that time, all we were focused on was the priority of the debtor in possession financing, which was very high against other creditors, and the interest rate. What happened since then, so over the next 15 years, is that other aspects of the new debtor in possession financing that was received by debtors became much more salient. So debt covenants, requirements that were in these debt instruments that I don't remember anybody paying attention to them in 1990 or 1992. But when those provisions started to become more common, they were then used for other purposes other than their traditional purposes outside of bankruptcy. Covenants and so on outside of bankruptcy are meant to reduce the risk of a lender. A covenant and other similar sort of provisions in debtor in possession financing might be used to change the course or to affect the course of the bankruptcy. And so it started to become a purpose and a practice of debtor in possession financiers, lenders who were coming or creditors who were coming to provide debtor in possession financing. They did that because ultimately they wanted to be the owners of the assets or the owners of the company coming out of bankruptcy, and this was the road to doing that. That nobody thought in those terms in the 1990s. So debtor in possession financing became much more common from, let's say, the early 1990s until, I don't know, you can say 2010, partly because companies were going into bankruptcy much more financially distressed with much more serious liquidity problems because they had much more debt on their books. And therefore, they needed much more urgently a fresh supply of funds. And because bankruptcy in the United States in Chapter 11 became a forum for corporate acquisitions, for the sale of either companies or of assets. And the debtor in possession financing was an important instrument in that strategic maneuvering in bankruptcy involved in the sale of assets or the sale of the company. So where are we now? We're now in the position where virtually every company has some new post-petition debt and possession financing. Very, very different from 25 or 30 years ago. And second of all, the debtor possession financer now often has longer term interests than just simply making a good return on the new loan. They have some interest in the company or the assets of the company after it emerges from bankruptcy. The strategic use of debtor possession financing is one that has raised some concerns with scholars and academics, where the proposal has been to try to police that use, I should say, the abuse of debtor and possession financing for strategic acquisition purposes. And that's something we could discuss, but there's no question right now that the companies that are going into bankruptcy and in the pandemic, most of them are being forced into bankruptcy because they have serious liquidity problems. They simply cannot pay their obligations as they come due, and therefore they desperately need new financing. And it often is part of their strategy, or they've already determined where they're going to get it before they even file for bankruptcy. And before I just conclude on that introduction, Vinny, I just wanted to also say that there is a distinction that Sheila mentioned, I think currently, between the large companies going into bankruptcy and the smaller companies. There is apparently a fair amount of capital there, private capital, to provide debtor possession financing for large companies that are going into bankruptcy in all the industries, the retailers, the retail chains, in energy, even some of the large chains of gyms, physical fitness gyms that are going in, they usually can find debtor possession financing. Where it's a little bit more shaky is in small businesses, and that's where the government probably needs to step in. And the last point I'll make is that Congress has stepped in the United States to provide small business financing, but in a curious decision, at least curious from the point of view of bankruptcy scholars, the previous stimulus bill said that those loans would be available, but not to companies that have filed for bankruptcy. So they decided that it was meant to be used by companies that were going to stay out of bankruptcy, not the ones that file for bankruptcy. I don't know whether it was concern about congestion or whether there was just an antiquated view of what bankruptcy is. But in my opinion, and the opinion of many of my colleagues, the next round, when they make the next round available for small businesses, they should remove that restriction so that small businesses can get the loans from the government, which they may not be able to get from the private sector, while also filing for bankruptcy. So let me stop there. Thank you.
Thank you very much, Professor Triantis. I think here we should divide the discussions. I know that Professor Sacramone is researching exactly on small businesses bankruptcy, and we'll get there in a moment. But before that, I think we should try to discuss a little bit what are the bumps on the road and the challenges of the debtor in possession financing in Brazil. We got a question from the audience that relates to exactly the priority. Probably might be the #1 issue on why the debtor in possession financing is not as developed in Brazil as it is abroad, and probably here I'm being generous in this observation. But I'd like to hand in to Professor Satiro and to Professor Cerezetti in order to present what is currently wrong here and how could we try to correct, to address it.
Let me just address just a few words in order just to introduce what Professor Cerezetti is going to say. But it's quite funny because as you mentioned that after a while your most important worry was to avoid abuse of debt financing. And well, I hope someday we'll have the opportunity to worry about abuse of debt financing. At this point, we're just hoping for debt financing. If the abuse came with, we can deal with later. The point is, well, when the law related to bankruptcy in Brazil was first written and came into force, there was one specific measure that intended to stimulate debt financing, but it was not effective at all. So it's quite clear now that it was quite clear that we had to find another way to make viable debt financing, and that came by stimulate bargaining among debtor and creditors. So they should bargain, find a way to do that, and submit that to the judge, and the judge would approve any sort of financing, but with no kind of priming, no kind of priority, accepting the regular priority of any kind of loan. And well, in the first case, a very important case we had here, that was Oas Case, an international case, but a very important case here. We had this kind of agreement between debtor and creditors, but finally there was an appeal, and the court decided that that was not a good time for the financing, and decided that the financing was too large for the company, and what we had is we finally didn't have the finance at all. So after that, I would say debt financing is something that we want to have in our legal system, but we don't really have it. It's part of the amendments that are being proposed by the bill that is in the Congress right now, and definitely we need to change things in order to make them viable. And the second point is banks, and we are a country that basically depends on banks for lending. We have a capital markets, but it's not a strong capital markets and and we have some other vehicles for lending money, but they are not expressive. So companies actually depend on banks for lending money, and central banks impose serious restrictions for banks to lend money to companies in reorganization. Something similar to what happened to American government about bailing. So what happened here is banks, it's not a good business, it's not a good opportunity for banks to finance companies in reorganization. So this is something we actually have to change. That is a very quick view of what we have now. Sheila certainly has more to say about it.
So I would just very, very quickly add that what we have here, I think it's a lot of uncertainty. So potential lenders, they are afraid of getting paid at all, and when will they get paid? Will they have any sort of priority or not? So I think in terms of uncertainty, then there is no interest in lending. In this case, OAS was a very good example that lenders should be really afraid of what is to come. I believe we need rules on this. The bill that we are now discussing in Congress might not be ideal, of course, but we need some sort of clear rules and then some rulings so that lenders would at least know what they can expect. And then we can maybe see the surge of a market and the use of debt finance. I think I agree with Souto when he says, someday I hope we'll see some abuses here. First of all, we need some use of the mechanism or of this sort of lending.
Thank you. Professor Francis, would you like to add any comment on how the market developed for debtor in possession financing, and what should we expect once the priority rule is clear in Brazil and we start developing a market on post-petition financing and exit financing? What the market will how the market will answer to it, and what should we expect?
So it's hard for me to speculate on what would happen in Brazil, either how the market is structured or whether there are, outside of insolvency law, whether there are other regulatory restrictions on banks and so on that they would have to overcome. But it seems to me that the comments that have been made about the importance of the certainty of priority seems to be key. I mean, I think in the United States, you know, once you know that you have the top priority if there's liquidation and that you have to be paid before a confirmation of reorganization plan, you know that your risk is not zero, but pretty low to zero. And so you can get a healthy interest rate, you can get fees and so on with a low risk. Now, my guess would be that people would run to try to get those opportunities. And in fact, I should say something else about abuse, and I take your point about being less concerned about the abuse at this point. But one of the earlier signs of abuse was that it was so good, it was such a good deal to get debt in possession financing that the companies didn't even put them out for bid. They would just go to their favorite lender, the one that would treat the CEO the best, and say, hey, do you want to be my DIP financer? And the bank would say, sure, sure. And I would look at that and I'd be concerned because the banks that were providing the DIP loans were getting super competitive because there was no auctioning of this opportunity. There was no competitive bidding for the opportunity to provide DIP financing. So the rates of return were absolutely outstanding. Then I think, as has already been said a couple of times, the key is to guarantee the priority. And once you have that there, then I think you would expect the market would take care of the rest. I just wanted to add one other thing. About legislation versus judge-made law. Just as an interesting contrast, in Canada, the reorganization statute is extremely short, is not very detailed, and there is no specific mention of DIP financing. And yet it is an important part of Canadian restructuring, and it was created by the judges there. The judges used their discretion under the Act to come up with basically something very similar to debtor in possession financing with a priority that was necessary to entice the lenders to come forward. Now, I don't know whether that's easier in a common law jurisdiction where judges more used to that sort of discretion, but it is interesting that it happened without a single word in the statute that they were using that involved DIP financing. But it has become, again, just like in the United States, very common up there. So I presume that what's been said about the importance of priorities is the key to opening the floodgates.
And Vinicius, if I may add something.
Of course, please, Fabio, go ahead.
So these discussions about comparative law are very interesting, and many times I see there is often a huge temptation to try to mimic the approach of a system that works very well, but we have to understand that the markets are very different. So I think that the point that Professor Satiro made about changing the banking regulation is critical, because if there is an appetite from the market to extend credit to companies that are in distress, that can be a game changer. And there are other rules that are more general and don't apply to DIP financing specifically that are also very important, such as the appeals process, how willing courts are to change a decision of a lower court, or how willing creditors or even the debtor are likely to file appeals. And if there is lack of certainty as to the final judgment, this can be highly problematic. So a comprehensive solution should not only focus on deep financing or try to replicate a priming lien mechanism that there is in the US, but you need to think about these issues more holistically, and probably the markets, it's a good place to start.
Great point, Fabio. Thank you a lot. So the other door that was opened right into this discussion is the financing and in a broader view, the judicial reorganization of small and medium-sized enterprises. I'd like to ask Professor Sacramone to share with us his research on this topic and why it's not common, why we see so many huge bankruptcies in the headlines of the newspapers, and why it's not working for the small and medium-sized companies.
Yeah, actually, in the newspaper, we have Odebrecht with 50 billion of reais in debt, but actually, when we see the data, we just analyze that there is 44 times more frequency of a judicial recovery in a big company as in a small company. In Brazil, as we have lots of foreigners here, we have 88% of small companies in our market. So the gross amount of enterprises are actually small companies, 88%. And in the state of São Paulo, our economic most important state in São Paulo, we have during 10 years of recovery of organizations in general, we have 210, actually just 210 lawsuits of organization with small companies. So it's actually a really, really small number. When we analyze this process now, actually this organization, we can verify that we can see all of the problems that this small company has. So in addition to the first, I have the data about it as well, so we can show it. Is easier to see. Actually, it's here. Oh, sorry. Yeah, here. Can you see? Yeah. I will put on that. Yeah. So this is the process in Brazil regarding the presence of active entrepreneurs in the state of São Paulo until July 31, 2017. And it was revealed that the large companies here in this data, we can see the companies that has a revenue between 2 million and 10 million at least are the most frequent in our judicial organization process. So if we can see this new data, we have 4 million small enterprise, and actually large companies, we have just 635,000. So when we see this graphic here, this data here, but actually the frequency of requests for judicial organization in relation to the existence of the active entrepreneurs, we have a different view of this data. We have 44, as I just tell, we have 44 times more big companies in the judicial organization as we have a small company. And when we look, or when we analyze the problems of these small companies in our reorganization process, we can see the main problem of this is the lack, the reasons for dismissal of this reorganization process. We have the lack of indispensable accountable documentation. So these small companies do not support the expenses for the regularization of its financial statements. And in Brazil legislation, we have to show the past 3 years of the financial statements that this company don't have. And second of all, the main problem is court costs. So we have from 106 lawsuits, we have 10 companies that cannot or that could not support the court costs, so have this reorganization dismissal. That's why if we are thinking about a solution for small companies in Brazil, the court is not a road, is not an alternative for this small business corporation to reorganize its financial or economic or financial, because it costs too much. In Brazil, actually, it's not so expensive as in the United States, but even here, the cost is a barrier, is an obstacle for proposing the judicial recovery in reorganization.
May I make a comment on that?
Yeah, sure.
So that's really interesting, and to me it makes me think, okay, what's the goal? In other words, should we encourage more? Should we change or do reform in order to encourage more small businesses to go into bankruptcy or not? And you wouldn't say, for instance, take an extreme example. You would say, well, very few court cases involve loans of less than $50. Well, you'd say, well, that's a good thing that they don't. So I think we want to have a sense of what our objective is. And I think it's also true in other countries as well that small businesses don't file as often. And I think partly it's the point that you made that the costs might not be worth the benefit of going into bankruptcy. But the other reason is that very often they just have one significant lender, one bank or what have you. And when you look at the United States Code and the bankruptcy system, it's really designed for a debtor that has multiple creditors that cannot reach agreement on what to do with the assets, on how to reorganize the capital structure, how to change the obligations over time, and therefore they go into bankruptcy as a collective process. The U.S. Code is really not meant for a debtor who has one lender, who has one significant bank lending it. And so to the extent that the small businesses, let's say, in the range that you're looking at are like that, they simply get most of their capital from one bank, then one might say it's a good thing that they're not filing for bankruptcy, because that's not really what a bankruptcy process is there for. I mean, under the old Anglo system of receiverships, small businesses didn't go into bankruptcy because simply the one lender would simply appoint a receiver, and all the restructuring would be done by a receiver rather than through the bankruptcy process. So I guess that's what I would throw out there to see how does this gel with the Brazilian situation. Is it true there as well that bankruptcy is meant for companies that have a more complex financial structure? Or is it also meant for companies that have a very simple single large lender mortgagee, shall I say?
Well, I think the primary intention was a kind of one size fits all, but that's definitely not what happens. And all the procedure is too complex and too expensive for small firms, for micro enterprises. And what we see is there is not a nice rate of success in approving good plans if we consider just small and micro enterprises. So probably the procedure should be much more non-judicial, much more well, we should not use the expensive structure of judiciary for this amount of small companies that have difficulties and etc. Actually, I have some doubts if reorganization as we know it should be appropriate for a small business, maybe a sort of a different liquidation a quick liquidation would be much more effective. But this is something that is shocking when someone talks about. So it's not a very popular comment.
But it makes a lot of sense.
Great. Thank you for your considerations. I think we could move on to the third part of our webinar. It happens to be cross-border reorganizations from the U.S. perspective and its implications for Brazilian companies. I'll ask Fabio to give us a brief high level of main restructuring tools available to foreign debtors under the U.S. Bankruptcy Code, and then we can move to specific questions on that.
Sure, that makes a lot of sense. So I would start by saying that the US Bankruptcy Code includes several provisions that are expressly extraterritorial, and that approach was thought from the outset, and in a context where there were less global insolvencies, but the way that the law developed in the US was in an effective way, and nowadays there are so many cross-border bankruptcies. So you can think of the US system as being both an exporter and an importer of bankruptcy cases. So you can think of the importer role if you think about Chapter 15 of the Bankruptcy Code, and that's the chapter that implemented the UNCITRAL model law on cross-border restructurings, and that's the chapter that allows foreign representatives to commence ancillary cases in the US. So those cases are intended to facilitate the implementation of cross-border restructuring. So, for example, a Brazilian company files for bankruptcy in Brazil when you need to implement a restructuring in the US, and you use that. So that's an importation of foreign bankruptcy. But you also have exportation of bankruptcies, and that's was less known in countries like Brazil. But now I think everyone's familiar with this possibility because several Latin American airlines have recently filed for Chapter 11 in the US, and unlike a Chapter 15 case, a Chapter 11 case is known as a full case, so ordinary restructuring case under the US Bankruptcy Code. But by no means those are new cases or a new possibility under New York or US bankruptcy law. That this possibility existed for a long time, and but now this is more known in Brazil. There were other famous cases involving foreign debtors that filed straight for Chapter 11 in the US. There is one case involving Edelnor, which is a utilities company from Chile that filed in 2002 for Chapter 11, and there is a Harvard business case study about that. It's a very interesting case. You have also a company that deals with public transportation in Chile, Alsacia, which filed in, I think, 2014. You have Maxcom, which filed last year for Chapter 11, and Maxcom is a telecom company. So you have several examples of cases involving Chapter 11 and foreign debtors, and even debtors that have most of their assets in their local jurisdictions. And let's say international Chapter 11 cases are also commonly used in certain sectors of the economy. For example, in the shipping industries, where groups have assets all over the world, oftentimes Chapter 11 can be a very attractive solution because foreign investors are familiar with this process, and because of the extraterritorial reach of the bankruptcy code. So I think in light of these recent developments, LATAM filed for Chapter 11 I think a month ago now. So this is a topic that's fresh. So it's interesting to discuss this from a comparative law perspective, as Brazilian scholars and judges become more familiar with how Chapter 11 actually works in practice, not in the books. And also from practitioners, it's also interesting because you become more familiar with the tools that are available and the strengths and weaknesses also of Chapter 11 cases.
That's great, Fabio. Thank you so much. If we agree, we can move on to more specific questions. So just trying to summarize, starting with chapter 15. What are like the lessons learned from these chapter 15 cases in the US? What's what's important for foreign companies seeking under the model law for the recognition of their bankruptcies in the US?
Okay. So Brazilian Chapter 15 cases have been very important for from the US perspective, not only from a quantitative perspective, but also in terms of quality. Brazil, in terms of quantity, is, I think, the fourth main source of Chapter 15 cases in the US. So it's a very relevant jurisdiction, which is interesting because you see US judges becoming familiar with issues that arise in Brazil and familiar with Brazilian law. I was involved in the Constellation case, for example, and in hearings, the judge was guessing what were the issues that were arising in Brazil, which was very interesting. He was referring specifically to substantive consolidation, for example, and it's interesting to see how judges become more familiar with foreign legal system, and I think that's an excellent signal. And so there are two main types of Chapter 15 cases. They are usually used in connection with liquidations or reorganization. I think the most interesting cases from, in terms of lessons learned, are the reorganization cases here, because as you may imagine, Chapter 11 is based on a model law, and model laws typically have very broad language. And normally a US bankruptcy court is a court of equity, so it has very broad discretion and powers. And if you couple that with a very broad statute with very broad standards, you could worry about how protectionist a US courts would be, or how deferential it would be to a foreign country like Brazil, which has a system that's significantly different in many aspects. So what the cases of Brazil have shown, and it was very interesting, I think Rede was a very important case in that regard, is that US courts are very differential to decisions of Brazilian courts. So it is a high bar. It's pretty difficult to convince a judge to exercise his or her discretion not to enforce a Brazilian court order in the US. You have to establish, for example, that there was not sufficient due process, or there are some serious violations of basic principles. So that's pretty difficult. And so it's interesting to see how the body of case law in Chapter 15 has developed and promoted certainty and speed in a context that's critical, right? So for you to implement a restructuring that involves oftentimes multiple jurisdictions, which we saw that in Brazilian cases like in Oi, where you had discussions in Holland, in Brazil and the US, or in other cases involving smaller jurisdictions. This is critical, and the US courts, in my opinion, have done a great job in being differential and allowing these restructurings to be implemented in a smooth way.
Great, thank you. So it's a great overview on Chapter 15. Professor Sachiro, please go ahead.
May I add one comment? Well, United States now and now Singapore as well, they are kind of offering bankruptcy jurisdiction as a product. Singapore explicitly, and Netherlands, they intend to do that, and as far as I know, UK want to do that. A recent paper by my nice friend Aurelio Correa, he suggests that it's easier for a country to adopt a model law and then recommend its economic agents to file for bankruptcy in a country just like Singapore or United States, than struggle internally in order to get a better insolvency law, what may take time, and etc. Do you think that it's viable? Do you think that this kind of explicit forum shopping that happens in some sectors, do you think that this is a kind of a tendency?
So I'm a little bit skeptical about that. I think let's take the case of the US first. Chapter 11 can be a very powerful tool in some contexts, but you have to have a very specific set of facts in order for it to be attractive to a company in Brazil. And I think there are so many cases where, for example, if you're dealing, if a government is a key creditor, or if the main base of creditors is in Brazil, or if you have situations where you really need to enforce foreign court orders in Brazil. And I think, as was discussed in the beginning, Brazil has not, for example, adopted the model law, and the model law is something that's used to internalize decisions, not to export decisions. It's highly uncertain that you'll be able to implement a restructuring in a country like Brazil if you file for Chapter 11 in many scenarios. So I think it is very difficult for Brazil or for Brazilian lawyers to be losing their jobs because of lack of demand of Brazilian law. I think what these recent cases they show is that it is very important that you think about the possibility of filing in the US a main case, a Chapter 11 case, because that can have significant advantages to you. And this, again, as I said, this is not something new, and this is considered, I think, in every single transaction or every single restructuring. One of the first things that we tend to think is, should we file a Chapter 11? And you may think that as US lawyers, you'll be more familiar with the system, you can have more control, but oftentimes it just doesn't make a lot of sense. And also you have dynamics, right? Internal dynamics. In Latin American countries, you have shareholders playing a more significant role in restructurings or in insolvency proceedings. And in the US, that's less the case. So you tend to have a risk of losing control of your process. And you can see that as a deterrent, especially in a country like Brazil, where you have significant concentration of ownership. So, and then Singapore, not so familiar with the system there, but I can see lawyers having a hard time working overnight to deal with that. And then I think there are cultural issues, language barriers. It's difficult. So I would say that I'm taking these recent developments as a grain of salt. I think that they show that Chapter 11 can be very, very powerful, especially in certain industries like aviation, for example, and we have 3 cases demonstrating that. But for general cases, I don't think there will be a lot of regulatory competition between the US or Brazil. And I see much more a path of cooperation in these 2 fronts, Chapter 15 and sometimes Chapter 11. So I'm less concerned about this risk of forum shopping.
Great. Thank you, Professor Satiro. Thank you, Fabio. Another question to you, Fabio. You're under the spotlight right now. So going back to Chapter 11 cases, can you develop a little bit? So what will be the main benefits for a foreign company to filing as a foreign debtor, and the eligibility requirements, the basic eligibility requirements that must be met by a company interested in filing for protection in the US under the Chapter 11?
Sure. So let me start from the eligibility requirements, because those are surprising. So to be able to file for bankruptcy in the US, many people don't know, but you don't have to be insolvent. And that goes back to the question of financial distress and economic distress. But you don't have to demonstrate to the court or to your creditors that you're insolvent. That's one point, and that applies to all restructurings. The other point that's interesting from a cross-border perspective is that you have to establish that you have property in the US. But that's not actually a bar or that prevents you from filing, and that the very same requirement applies in Chapter 15 cases. So even in Chapter 15 cases, there are cases that say that you have to have property in the US. So that begs the question, what's property in the US? And it's very simple. So you basically have to pay your lawyers. If you pay your lawyers, if you have a retainer account with your lawyer, you have property in the US. So that's done. So very easy. But that doesn't mean that a US court will have exercised jurisdiction in any case, and there are very interesting cases that the courts have proved that. So I think the most interesting case, in my opinion, is the restructuring of Yukos. Yukos is was a Russian company that, according to its main shareholder, was expropriated by the Putin government. And as part of its strategy, in addition to several arbitrations around the world, Yukos filed for Chapter 11 here in the US. And Yukos was an oil and gas company, so its main assets were oil reserves in Russia. So part of its assets were buried literally in Russia. And then the court held that it should not exercise jurisdiction in that case, because it was not practicable to expect that you could implement restructuring of a Russian company in the US. So courts would take a look at that. It's not a rubber stamp exercise, but it's increasingly likely that you'll be able to satisfy the requirements and become eligible. And there are several benefits of filing for Chapter 11. You have economic benefits and legal benefits. I think we talked about some of the economic benefits, more robust market for the financing, and you have more broader and narrower benefits from a legal perspective. You can say broadly that you have the US court system and regime that investors are very familiar with, and it works quite well. And then you have certain substantive rights that are important. For example, some rights that you don't have in Brazil. So in Chapter 11, you have the right to reject executory contracts, which is something that you don't have in Brazil, which gives you the right to effectively breach a contract and treat the damages arising out of that breach as pre-petition claims. So you basically can get rid of unfavorable contracts, and that's quite significant. Also, another difference relative to Brazil is preferences. And like in Brazilian judicial reorganization, you can file preference lawsuits and recover monies to the state. Of course, that will be very subject to the facts of the case, but that can be a significant benefit. And it's also more generally, Chapter 11 provides a very good forum for negotiations, multi-party negotiations, and companies can take a lot of advantage of that to design a process and a transaction that works. And the fact that if you have creditors that are exposed to the US system, you have a reasonable level of comfort that even foreign creditors will comply with US court orders.
That's great. I would like to ask one last question, and then we unfortunately have a hard stop getting super soon due to our panelist schedules. So Fabio, one last question. So what are like the main challenges that a Brazilian debtor can expect and will face once filing for bankruptcy in the US?
Actually, and Fabio, just a minute, can I just add a comment and add a question? And what about the creditors that are here in Brazil? Is the effect of the decision of the U.S. court here in Brazil forcible, or can my creditors can file for executory or something here to attach the assets of Latam, for example, that has just got a reorganization here in US? What about the creditors here?
So I think that's also a question for you, right? Because as a matter of US law, the court orders will be I'd like to think that the parties will comply with these court orders. But unfortunately, we know that some types of creditors, mostly trade creditors or employees, may not have any context with the US jurisdiction. So as a matter of practice, you may not be concerned about not complying with a US court order. But if you have exposure to the US jurisdiction, like a major bank, a global bank, for example, you have very strong incentives to comply, because if you don't, you may be held in contempt of court and you can be subject to significant penalties and sanctions. So it boils down as to how the foreign decision will be internalized in Brazil. And to my knowledge, this is like a long and unpredictable process. So this is challenging. And there are tools, as Professor Jancis was explaining, courts, U.S. bankruptcy courts have a lot of discretion, and there has been a practice here in the U.S. that has developed over time and takes into account this fact that it can be very difficult to enforce for a U.S. court order in Brazil, for example, or in other countries that have a similar legal regime, and that's one of the main challenges. So in connection with that, oftentimes debtor asks, and the court grants special relief for that. So it's common for U.S. bankruptcy court to allow the debtor to pay in full local employees or local trade creditors, because they know that these creditors can exercise their rights not to continue to supply or to exercise rights under local laws, or there might be, for example, personal liability to employees or shareholders, directors, officers that can be highly disruptive. So U.S. courts tend to grant that relief when asked, and that facilitates the process. But it's again challenging, and it's one of the key points. Another thing that I'll add is that the bankruptcy code doesn't have it pays a lot of deference to non-bankruptcy law as a matter of principle. So the bankruptcy code is federal law, but for several substantive rights, or most of them, bankruptcy courts look to local law. And by local law in a domestic case, I mean, for example, state law, U.S. state law. But in connection with a foreign or a cross-border bankruptcy, you may look to Brazilian law. So several matters will be governed by Brazilian law. For example, fiduciary duties, regulatory approvals, corporate matters, and several other points. So that's another challenge, because you have a New York judge, for example, we may very well have to decide cases and issues based on Brazilian law, and as you may imagine, that's quite challenging and complex to do.
Great point, Professor Sacramone, and thank you again, Fabio, for this comprehensive description and Q&A for Brazilian trained and newly grads LLMs that, although we're students of Professor Triantis, we still have a lot to learn on that. So I'm afraid we'll have to end this session. Our panelists were super punctual, and we'll have to do the same for their next event, their next commitments in their agenda. So I would like to thank you all. I'd like to give our panelists the time for final remarks, and thank you again for your availability and your enthusiasm in discussing these topics with us, and we could start with Professor Sheila.
Sorry, Vinny, I couldn't hear you. You were saying thank you. I will say thank you back, but I couldn't hear your question, if there was one. I only listened to you saying thank you, and then I will start with Professor Sheila. So I don't know
no
what
problem.
to say except for thank you very much.
Great. Yeah, just final remarks, but I think that's pretty much it. I know Fabio would like to invite us for an event. He's speaking on that. So. And I know Professor Satiro is also involved in the organization. So go ahead, Fabio, please do it.
Yeah, so I think we'll be talking more about Chapter 11 issues at the TMA. I think it's 17th of August. Professor Sacramone as well is involved. So I think it will be a good opportunity to talk about these issues. And it will be in Portuguese too.
Great. Once again, Professor Triantis, thank you so much for joining us in this lunchtime in California. And it's great. I know I've heard it from 3 professors that are here that you're going to be invited to give a lecture in their post-graduation course in Brazil pretty soon. So stay tuned. And yeah, thank you again.
Thank you. Thanks for the opportunity, Vinny, and for putting this together. I think comparative perspectives are crucial to reform and to understanding one's own jurisdictions, and I've really learned from this. Thanks.
Thank you, Professor Sacramone. I know you deal a lot of these issues and probably facing Fabio summer soon. And thank you again, and it's an honor to have you joining this session.
Thanks a lot. I think the discussion is for us in Brazil, the better that, and first of all, I would say that we have to discuss so we can make our legislation a little bit better. Probably the US is a little bit more sophisticated as us, at least until now, and we have most to learn. So thank you all. Thank for all. Yeah.
Thank you. Thank you, Professor Sacramone. Professor Chiro, I'll leave with you for the final words, and thanking again our audience. And we are 30 seconds behind schedule, so we are good.
Thank you for the invitation. Thank you for the opportunity of being with those panelists, people that I really enjoy and admire. And thank you, Vinicius, for organizing all this for us. Thank you very much. It's been a great time. I really enjoyed it. Thank you.
Thank you.
Muito obrigado.
Obrigado a todos, and have a great afternoon or evening somewhere. Thank you. See you soon.